Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, we're here with Rahul Ravipudi, who is not only a great trial lawyer, a great human being, but actually has become a friend of mine over the last few years. Really started in the pandemic. We really got to know each other. We knew each other in passing, I think, before that, but didn't really know each other until that great thing called COVID walked into our lives. So we're here to rock and roll with Rahul. And Rahul, how long have you been practicing law now?
25 years.
25 years.
Time flies.
And yeah, such a interesting journey. But how did you, tell us about when did you get the inkling or the idea that, hey, I want to be a lawyer. So where did that come from, Rahul?
Yeah, no, it was a long time ago, and I'd say it was sometime in high school that the concept of and the thought of wanting to be a lawyer came into my mind, and it never really left after that. And really, the genesis of it is from my parents and my mom in particular. I come from a family with no lawyers. My parents came from India. They came on scholarships, which is $75 in their pocket, and an opportunity to go to Vanderbilt University in Nashville, Tennessee. And my dad came first and made friends with others in the Indian community over there, which was a very small community, as you could imagine. And then he became part of the welcoming committee. He was getting his PhD in chemical engineering. And then my mom, 2 years later, gets a scholarship to go to Vandy, and my dad meets her at the airport and falls in love with her immediately. And so she was getting her double master's in nuclear physics and in environmental engineering. And so I'm the least educated person in my family, by far. My brother's a doctor, went to med school. He's an interventional cardiologist. And then there's just stupid old me. And so I was growing up where academics was really important, science was really important, and anything else didn't make any sense to anybody in my family. But my mom, as an environmental engineer, she worked for the California Energy Commission, and what she would do is she would go to all those oil rigs off in the Pacific Ocean. You can see them from the beach, and she would evaluate them and levy fines on all these big oil companies, Mobil, Arco, whoever. And so every night at the dinner table, we'd talk about our days, and she would tell me about how she levied these fines on these big oil companies, and that tomorrow she's going to have a meeting in their big offices with all these lawyers who are going to try and bully her and tell her that she needs to withdraw all these fines and she was wrong and they were right. And then the next day comes, and my mom does, I go, how'd it go? She goes, there were like 9 lawyers in their fancy suits, and by the time they left, they got nothing out of me, and all the fines were confirmed, and they have to pay them all. And just that advocacy that was happening back and forth, and if you get a chance to meet my mom, Dan, she is 5 foot tall and an absolute force. And so nobody screws around with my mom. And so just kind of listening to the way she advocated, the position she took, the belief and conviction she had, it's like, I want to do that, but I don't want to be an engineer. And it was at that time that I decided I wanted to go down the legal route. Odd that I'm picking a profession where everybody was losing at the dinner table, and I thought that's what I want to be. But that's kind of how it all started. And I thought I was going to become an environmental engineer, but everything there changed when I actually went to law school and my eyes opened up as to all the different areas of practice, what it actually means to be an environmental engineer, which is, to me, is incredibly boring, just regulatory work. And then I started to sort of find my way to getting to the practice of law that I love, and I've gotten the chance to do now for over 25 years.
Where did you go to law school?
I went to Loyola in Los Angeles.
And you currently teach there, is that right?
Well, I taught there for 14 years. I'm on a version of a sabbatical. I took a year off, and I've been connecting with the law school, and hopefully I'll be back to teaching there in the spring. And I taught
That's great.
trial ad for about 13 years, and then I convinced the school, and I sat with them. I said, hey, trial ad was my favorite class in all of my law school, and I love teaching it, but it's awesome because it's a practical class, and it teaches people the real world. But the real world is when you show up in a courtroom and answer ready for trial, the first thing you do is not an opening statement. You pick a jury. And no class teaches that. And so I started teaching a voir dire class over there. And you actually guest lectured once, which was fantastic, Dan. So, but I'm really proud of actually getting the chance to do that and then giving these students the opportunity to actually hit the ground running once they pass the bar and start to practice.
That's so great because, when you're in law school, I just look back to my lifetime in there and it's like, I never considered being a personal injury lawyer. Never even considered it. And it seemed it seemed kind of like like a dirty, you see all these ads and everything, you just get the wrong impression. And it's, but it's like now there's this guy, I think his name's Yusuf. He's got this program for law students to get connected with personal injury lawyers, and your firm is actually doing like a virtual job fair. And so I ran into him at the AHA last weekend, and I'm really, in Vegas this year, my goal is to get 100 law students there. So
it's awesome.
I'm going to give 100 law student scholarships. So if you're a law student or you know one, and they want to write me a letter or an email as to why they want to be a plaintiff's lawyer and why they want to come to Trial Lawyers University, I'm going to sift through them and try to find the best 100 candidates to hopefully have a profound effect on their life. Because I can only imagine, being in law school and coming to Trial Lawyers University and just meeting all the people like you and Panish and Rowley and Claggett and Randy McGinn and, the trial consultants like Eric Oliver, Sari De La Motte, just Satch Oliver, everybody's coming. Just so many great people are going to be there the whole time too. And you really get to know people and get an idea for your life. So I'm really stoked about that.
That's fantastic.
And so you graduate from law school, but how did you get involved with the plaintiff's bar? Because you actually got started before you got some. Where did you intern in law school?
Yeah. So in my second year of practice in law school, I clerked for the Ventura District Attorney's Office. And over there, they actually let me try cases, and I got to try all these fishing without a license trials and take them to verdict, and had a 100% conviction rate, which I feel...
Were they juries?
They were bench trials. And so I'd put on, the game warden, and he'd say, that's the guy over there. And then I'd put on the defendant, and the defendant would cry and say, I don't have the money to pay for this. And half the time I'd walk up to the judge and say, hey, I feel really bad for this guy. Can we just, drop the charges? And everybody just said, you got to finish through. So I'd go through and so it wasn't hard, but it was really kind of interesting to go through the process and to get comfortable being in a courtroom, which is, half the battle. And then
it takes a lot.
While I was there, one of my buddies from my first year law school section, he worked at a firm called Green, Broylette, Taylor, Wheeler, and Panish. And he called me up and he said, hey, one of the partners here, his law clerk, is moved on and he needs a new one. Get over here right now and I'll get you an interview with him. So I put on my suit and drove over there, waited for the lawyer to come back to the office, and then got a chance to interview with him. And his name's Jeff Wells, and we are such close friends now. And I thank him every time I see him for seeing something in me that I didn't even see and giving me the opportunity to get exposed to this world of plaintiff personal injury. And so, Brian Panish was there, Brown Green, Bruce Broylette, Chris Spagnoli, Jeff Wells, and a lot of really amazing trial lawyers and influencers in the community. And so I got an opportunity to work there for about 2.5 years until I passed the bar and got to carry Brown and Jeff's bags at trial on a product liability trial and got to see how everything worked and how the workup was, which was fantastic, inspirational, and convinced me there's absolutely nothing in the world I wanted to do other than to be a plaintiff trial lawyer. So then after that, they didn't have a job for me. So when I passed the bar, they said they would help me get a job. And I got some opportunities from amazing law firms down in Orange County, but I wasn't quite ready to move down to Orange County. And so I asked Brown and Brian and Jeff, can you find me something in LA? So they said, well, I can call up Walter Lack. And Walter Lack used to, Engstrom, Lipscomb, and Lack, they used to be a defense firm, and then they switched to the plaintiff side after they did the whole Aaron Brockovich case. And so this is a firm where Brian started his career. And so they all called Walter, and I went and interviewed with Walter, and fortunately got a job there and worked on the second phase of the Aaron Brockovich trial for the first 6 months of my job there, and took about 300 depositions. Latham and Watkins was on the other side. And what a great opportunity to get comfortable with just the world of depositions. You know, the first one you do is nerve-wracking, and then after a few, you get more comfortable, and then after more, the nerves are gone, and now you're really focused on advocating for your clients. But then switched over and then started doing complex business litigation, aviation, securities, private investments and public equity litigation, legal malpractice, very little personal injury. I did that for about 6.5 years. We did the natural gas antitrust cases, went to trial for 6 weeks on that down in San Diego, and then ultimately the cases settled for a little over $3.4 billion. So by the time I was a 6th-year lawyer, I had been working on incredibly high-profile cases, incredibly sophisticated cases with millions of pages of documents, and trying to distill the most complex concepts into ideas that were digestible to a jury. And then after that, I got put on this one case, and Walter said I was doing so good. He's like, look, I'm going to trust you with this case. You're going to represent 35 tribes across the United States. And this is what ended up happening was when the United States was moving west and taking over all of these tribes' lands, they'd enter into these treaties. The treaties were simple. Native American tribe, you're going to get a small piece of land to live in. We're going to take a lot of your land, and it's going to be ours. And then we're going to take a lot of another large piece of your land, and we're going to lease it to farmers, and you get all the money. And that'll help you start to navigate and acclimate in this brave new world we're creating. Unfortunately, the United States government gave them all $0. So they took the land, never gave them any money. John McCain renewed the statute of limitations on it and said, tribes, you can go ahead and sue the U.S. government. So Walter said, this is your case, gave me a paralegal, and I was going to go up against 30-something U.S. attorneys, and we were going to get to the finish line on it. I was going to win, and there was no concern in my mind about that, but I was kind of at a crossroads in my life where I thought, I want to be a trial lawyer and try cases. I'm going to get an amazing outcome for these very deserving tribes, but it's going to take me about 7 years. I'll be a 14-year lawyer, and I will not have tried a case in the last 7 years. It just wasn't what I wanted to do with my career. And so I started searching for opportunities, and I got one opportunity at another firm and gave notice, and I was going to go try a lot of cases there. And it was about 6 months after Brian, Adam, Kevin, they spun off from Green Broilette and created the law firm Panish and Boyle. And so then Brian called me up and said, if you're leaving Walter, I would never take anybody from Walter. But if you're leaving, you got to come over here. And that's what I did 18 plus years ago. And it's been the best time ever.
I can only imagine. And you guys really built quite the law firm over there. How many lawyers you got now?
Got probably 45 now.
Yeah, I know a lot of them. Fortunately, from the pandemic, it really, it was so cool because I got to meet so many lawyers that are part of your firm that, again, most people don't know, have never heard of, but do so much of the critical work to build these cases and get them ready to get to trial or to resolve. I know most of them resolve because you do such a great job, putting them together. And the idea is to get the money for the client, not just to go to trial and show people can beat people up. But It was a great time to get to know everybody. And, so you've been here with Panish now the last, this group for the last 18 years. And so on those 18 years, I guess what accomplishment as a trial lawyer, are you most proud of?
Oh, that's a tough question, Dan. It's honestly, it's every day is better than the last day. So, we have the privilege, and as a lawyer, you've got to develop and adapt all the time, right? And so I continue to learn every single day about different litigation strategies, ideas, messaging. We're the I'm the type of person, and we're the type of law firm where we don't like leaving any stone unturned. The best practices are not to just take what we've done in the past and say, okay, let's do a cookie cutter approach. So it's so fun to look at an individual case and try to identify the path to get to the truth and to get full justice for our clients, whether that's through significant law in motion, whether that's through exposing corporate fraud and concealment efforts, or whether it's through case framing and getting a amazing verdict. So I'm really proud of everything. And I'm really proud of the firm for really developing, and thank you for your comments, Dan, about everybody you've gotten to meet. We're really proud about developing amazing trial lawyers at our firm. And it's not something where Brian and I and all the other partners, Spencer, Robert Glassman, Adam Shea, Tom Schultz, where we just sit there and say, hey, we'll just do it all and we don't need anybody else. Even if that were true, we don't want it to be that way. We want everybody to develop to be the best version of themselves and to be the lawyers that they want to be. And I feel like everybody is rowing in the same direction with being inspired to want to help our clients and do things for the right reasons. And that is a very subjective statement, Dan, doing things for the right reasons. But the way I try to navigate it is, it's not what I want to do. It's what's in the best interest of our clients. And being prepared to try our cases day in and day out, not being afraid to be in the courtroom, because if that's the final destination, great. That just made my day. But at the end of the day, there's sometimes where so much money is being offered to our clients that never once do I feel that our ego has been put in front of our interests of our clients, so that we do things because we just want to do it, not because it's best for our clients. So I'm just proud of having the discipline that we've had as a firm to continue to try and do the right thing every single day for our clients.
I know the cases that you've been involved in, especially the ones dealing with some public entities, have not just impacted your clients' lives, but have impacted our society and made it safer places. But can you give us, I guess, some of the ones that come to mind that really stick out for you and the things you were able to do through these trials and through these verdicts?
Definitely. So early on, and I'll give you an example of one. There was a case, Junn versus Chaffee Joint Union School District. And in that case, our client's adopted son, 15-year-old son named Jin, he had to walk to a school bus stop. And originally, in the year prior, there were bus stops on two sides of a 5-lane road, an uncontrolled intersection. It's really called a multi-lane highway, where cars are going at 50, 60 miles an hour. And then for some reason, the school district decided to eliminate the school bus stop on Jin's side of the road. And so Jin and other students needed to cross this highway to get to the school bus stop. And sadly, on one day in December, just a few months into the school year, as he was walking, a woman driving a Astro van didn't see Jin, struck him and killed him. And she ended up pleading guilty to vehicular manslaughter. And the case came to me, and Mrs. Junn called me up and asked if I could help. And I started doing some research, and it looks like there's some case law and some statutes that say, and this always drives me crazy, the fact that you need a statute to do something that common sense dictates. There's a government code section that says, hey, you can't designate a school bus stop on a multi-lane highway without any control devices, no stoplights, no traffic lights, no anything. Seems like, I don't think I would want a school bus stop on the 405 freeway, and why would you ever do something stupid like that? But there's a law that said you can't do it. So I took the case and filed a lawsuit against the school district, and the school district destroyed and hid all of the evidence. They denied they ever had a school bus stop on Jin's side of the road. They said I was stupid for even thinking that. And then ultimately the case got dismissed by the judge. I had to go up on appeal, got it revived. And as we were preparing to go to trial, I hired an investigator who then went and canvassed the community. And we found a tiger mom who said, oh yeah, I know all about this case. As soon as this poor kid died, I emailed the school and I said, this better not happen again. I'm not going to allow this to happen to my kids having to cross this dangerous intersection, and had all these emails with the same people I deposed who denied having the school bus stops and all this stuff, who said, oh yeah, we had a school bus stop on the other side for reasons, for poor decision making. We eliminated one of the school bus stops and we're putting it back in the following school year. So don't worry, your kids are going to be safe again. And so I brought sanction motions against the school district, and ultimately the judge agreed, and we had a number of issue sanctions establishing liability. And everybody was represented, even the person who pled guilty to vehicular manslaughter. But as we framed the case for trial, the whole point in our theory was, this lady, Imelda Hughes, and Jin, they should have never met. Had the school district done their job, they would have never met. And the reason why you can't designate school buses in such a reckless and dangerous way is because it's foreseeable there'll be negligence on the part of kids and on the part of drivers. So you got to eliminate that. Jury came back and awarded $20.5 million to my client with 100% liability on the school district, 0% on the lady who pled guilty to vehicular manslaughter. But after that was done, I wasn't done. So then I filed a motion for sanctions against the district. Said you engaged in egregious discovery tactics and hiding all this evidence, and we want a lot more money. And because I did that, I didn't bring that motion with the true intent of actually getting an additional monetary award. I wanted them to do the right thing. And so through that motion, I was able to get the school district to say, look, here's what we'll do at your request. We're going to hire a professional third-party consultant. They're going to evaluate all of our transportation and busing practices to make sure we're doing it the safe way and the right way. And once we do that, I told them they need to actually publish it. So then they published it, so every other school district in the state of California then has the opportunity to see what a proper transportation plan looks like, and then hopefully implement that across the state in every other school district. And it was that type of non-monetary reform that I think helps make schools and kids safer across the country. And so we were able to do that through legislation on a number of other cases. We had the Paul Lee Bus Safety Act, where now we put into law and worked with legislatures to make sure kids aren't left behind on school buses. School bus drivers are required by law to scan a school bus and sweep it and walk through it before they leave the vehicle, and they don't do that. And so now the law that we were able to get put in after a tragedy for one of our other clients was that an alarm goes off at the back of a bus, and those have to get installed in every school bus every time the bus driver turns off their school bus. And the only way to turn off that alarm is for the bus driver to walk back and physically turn it off. And that then forces them to look through the vehicle and see if there's any students on the bus before they actually leave it. And that has actually led to a lot fewer kids actually getting left behind on school buses. Tragically, it still kind of happens, but at a frequency that's much less now that this law has been put into place. And that law in California then got broadcasted across the country, and a lot of other states started copying it. So it's not only made folks in the state of California safer, it's been something that we've been able to accomplish and make society in general safer. So just it's not something we get paid for, but it's part of our moral compass. And I tell everybody this: if there was some way we could implement change in a way that would eliminate the need for my job, I would be the happiest person on the planet, because that would mean that this is a safer society. Unfortunately, corporate greed and malfeasance continues to exist. And so, but I'm going to keep trying. So.
It's just it's the endless game, because they just keep popping their heads up. It's like whack-a-mole.
Yeah.
But I know you don't lose too often, Rahul. But do you have any loss or case that got away from you that kind of still irritates you a bit?
Well, I lost a case on summary judgment once that, I don't know, I always think about it. And so it's this case against AmeriQuest. I don't know if you remember that subprime mortgage lending company that sort of took over the country for a little bit of time. And what their practice was and how they made a lot of money is they would target low-income people who wouldn't be able to get a conventional loan for a home. And they'd say, hey, we'll give you a loan. And they would give them a loan, and they would charge them what's called a loan discount fee. If a person with good credit was able to get a loan for 6 or 7% interest, the interest rate for these targeted individuals would be around 11%. On top of that, though, they would be charged a 7% loan discount fee. And that would just say, let's say it's a $100,000 loan, they'd just add another $7,000 to the corpus of the loan and then charge them that 11% interest rate. And so I filed a lawsuit. It was a class action lawsuit against AmeriQuest, saying that you're engaging in unfair business practices, and because you're charging a loan discount fee, but you're not discounting the loan. And I took the depositions of everybody up to the executive vice president and would ask the same simple question. Hey, I see this. You charged a 7% loan discount for an 11% fee. What was the rate going to be if you didn't give them a loan discount fee? And every single witness said, I don't understand what you're asking me. Well, how much did the 7% fee you charged my clients, how much did that reduce the interest rate on the loan? That's not how it works. So is there any reduction? No. So I got confessions from everybody that this loan discount fee was just another padded charge, and it actually didn't discount the rate. Unfortunately, when on summary judgment, the judge said, well, with defense's arguments, whether it actually provides any benefit or not, I'll take you at face value that it doesn't. It was disclosed. And since it was disclosed, your clients knowingly signed off on the contract, and you don't have a case, and then dismissed my case on summary judgment. I was so bummed out about it because I didn't feel like that was fair. But there is a silver lining, because then about 6 months later, I open up the newspaper and I read that 43 state attorney generals settled with AmeriQuest for $450-something million for charging loan discount fees without providing a benefit to the customers. So the clients got justice, which was happy. And so it doesn't stick in my craw that much, but I was bummed out because I knew I was right, and I just couldn't believe that the outcome wasn't as I thought it should have been.
You see, a lot of lawyers of lesser character you might be upset that they missed out on their $150 million in attorney fees for fighting this great case, prosecuting it, getting it yanked away from them, and then having the government go and take care of it for them. But not you, so that's good. That shows you have an elevated state. you were just teaching at our last conference down in Huntington Beach in June, and we're doing that one next year, June 4th through 7th. I was really stoked about that conference. I was really because we bought out the whole hotel, and everybody's with us, and there's so many great trial lawyers there, and you were there for only a day, so hopefully next year you'll be there for a little bit longer time because But what'd you think of that conference?
I thought it was fantastic. There's a certain type of energy that comes with a conference that and a culture that you've developed, Dan. I know you hate getting compliments, so I'm going to try to avoid giving you compliments and just give it direct as to my experience. But it is pretty awesome when you've got 500, 600, 700 people who are all like-minded. Everybody who comes to the conference comes wanting to learn, wanting to get better, wanting to be better, wanting to share everything they know. And that type of collective wisdom and energy only creates more energy and more buzz and more enthusiasm. So it's just a great place to be. Everybody's so nice. Everybody's across the country has some amazing stories. And I've just learned so much from getting exposed to so many different people and so many different styles of litigation in so many different venues. And so it was awesome. I love doing it. I appreciate the opportunity to get to teach, and I appreciate getting the opportunity to teach on things that actually interest me, which sometimes are interesting to others and sometimes maybe not, but I think maybe should be. So it was fantastic, and I would like to stay longer. So hopefully next time I will get to.
Next year we'll plan further ahead. Like this time we're playing a little further ahead because in Vegas, I'm really stoked for that because not only you teaching, but all the great trial lawyers from your firm are teaching things that they're passionate about. In Vegas, October 16th through 19th, this will be your third time at our TLU Vegas. We took last year off, went to New York for a little side adventure. We won't be doing that one for a while again, but I'm actually thinking I was just in Nashville for the AAJ, and wow, what a great city. So much energy, and the music vibe is just, and the climate is wonderful. But we found this hotel there that's only it's a really new hotel. It's called The One. It's very boutique-y in downtown. It's only got 250 rooms. So I'm looking to do a conference there and buy that hotel out, and maybe next fall. But for this fall, we got Caesar's Palace. And so can you tell us, what are you going to be teaching at Caesar's Palace this year?
So there's a couple of things. So we're going to have an entire track, the Plaintiffs Ravipudi track, where a bunch of lawyers from my firm, and I work very closely with Sonia Chopra, who's our jury consultant on almost every trial I've done, and so she's going to be there with us as well. And we're going to cover a lot of things. One of the things that I'm going to be talking about is really telling the damages story and using examples. And one of the things that I see is, unfortunately, is sometimes we get so worked up and so passionate about proving liability that we don't spend as much time as we need to develop the damages, which is just as important, sometimes maybe even more important of a component of a case. And we're the spokespeople for our clients. And as their microphone, if we don't fully understand the intricacies of it, of their lives, the impact on their lives of whatever the loss is that's at issue in the case, then it's very hard for a jury to connect with you and then connect with your client. So we're going to show some examples of how we have prepared our clients and how we've worked up all aspects of a damages case and how that actually plays out. And hopefully it'll be helpful in giving some ideas to anybody that's there on how to work up their cases to get the full picture of the damages and then get full justice for your clients. And on a lot of these, we do a lot of arbitrations, we do a lot of trials, of course. And so in these cases, most of them, the awards have been north of $50 million. And so, there's no way I can convince a sitting judge or a retired judge, a jury of one, to award that type of compensation unless the evidence truly supported it. And if I'm able to convince one, I'm definitely able to convince 8, or I'm able to convince 12, if depending what the jury is in the venue I'm in. So all of these practices go back to what I really believe in, which is a universal truth. I don't think that we're so naive that we should be banking on tricking people. And if that's what your goal is, oftentimes you're going to get caught, and then it's going to be problematic. So I'm more interested in harmonizing all of the evidence so that it's irrefutable. And that can be both on the damages side and on the liability side. And so that's one area we're going to be talking about, and there'll be a lot of illustrations there. I'm going to be with Lissa Roberts and Rachel Gezersay in our office, who are both amazing lawyers. And then separately, I'm going to be with Tom Schultz and with Sonia and a few others, and we're going to be covering a lot of different topics of how to get your case worked up in the right way, both for trial, jury selection strategies, and case framing. And so this will cover all sorts of things, including when and when not to engage in stipulations, how to do direct examinations of treating doctors, when to do those types of direct examinations, when not to, so that you can get best get your message across, and then dealing with expert witnesses, both in direct and cross-examination, and then depending on the type of cases, what type of areas of voir dire you want to do.
Well, that's going to be great. And then you got Panish teaching and all the rest of your partners teaching on various topics. And I'm going to get podcasts lined up with all of them, and so that way they can share the substance, the deeper substance of what they're going to do beyond the words.
Yeah.
In prep,
I'll just give you one example of another one. So with respect to Brian, Adam, and Ian Sampson, they're going to be talking about product liability. And, Brian and Adam are, the stalwarts in the industry on that, getting like the biggest tire defect verdict, and then Brian with this $4.9 billion verdict. But they're going to kind of take that standards and what we have to deal with in California, and then explain some of the amazing things that we've been able to do under different legal standards, for example, in Nevada on product liability. So hopefully people will have some tremendous takeaways from that, because I know a lot of times people look at product liability cases, especially those involving vehicles, and they get scared. Oh man, this is a big investment. This is complicated. I don't know if it should be in my wheelhouse. And I think that after sitting through that program, I have a feeling people are going to be a lot more open-minded and wanting to take on these types of cases, because first of all, they're incredibly righteous cases. And then as you start to understand some of the intricacies of it, hopefully we'll be able to distill it and simplify it so everybody can feel inspired and wanting to help victims of such tragedies.
And besides the the PSR track, Sean Claggett is teaching with his folks from his firm, the Claggett Sykes Trial College. Nick Rowley is teaching with his partners at Trial by Human for the 3 days. And then we got so many other great trial lawyers like Michael Cowwood's teaching a one-day big rig boot camp on trucking, his master class. And Joe Freed's teaching for 9 hours. He's teaching on speed trial, on trucking. He's teaching with Satch Oliver about, because Satch just published a book, Depositions Are Trial. So kind of blending that concept with the speed trial with Joe, Randy McGinn, another one of your friends from the Inner Circle, Lloyd Bell, Ben Rabinowitz. He's going to be teaching about 5 hours. So it's it's so exciting because to bring these great people together, because usually if you go to any conference, maybe one or two of them will be there, and they're kind of called like the keynote speakers. And somebody said to me one time, "Oh, am I going to be the keynote speaker if I come?" I'm like, "Yes, you are going to be the keynote speaker. You and 80 other folks are all keynotes." So That's
I
how it
mean,
works.
it's just amazing. And, Sean has been such a generous giver of all of his knowledge, and is just such a great guy. And same with Nick Rowley. And I just love a lot of his philosophies and approaches on things. And it's been great to call all of these folks my friends. And so there are just so many great lawyers. I get so inspired by Lloyd Bell and the use of his demonstratives. If anybody's hasn't seen it and seen how he uses them, he put into my conscious something that I think was in my subconscious, which is demonstratives shouldn't require any explanation. And, I think a lot of us forget that and think that we've got to somehow create these complicated demonstratives that require explanation, and that's problematic. And he is just such a master at making that happen and putting together the most simple demonstratives on the most complicated medical malpractice cases, which I don't understand half of the Latin coming out of his mouth, but I understand the what went wrong and why it went wrong and how it shouldn't have happened. So it's, yeah, no, Dan, you've got an amazing lineup of people coming up, and I'm excited about that too.
Me too. And it's not just 8 lecture tracks. I think it'd be like 18 or 19 workshop tracks where people would break into smaller groups and actually practicing stuff. I know there'd be like a few rooms that have, stuff that I've developed on training the presentation skills of trial and controlling things like our facial expressions and our eye contact and our hand movement and our voices. Because, people never really practice their presentation skills. Some people develop them over time and do a really good job, but most people that I've seen are just not very good, let alone great presenters, and can improve tremendously. And then workshops with other folks teaching voir dire, and, like Sari de Lamott's teaching a half-a-day workshop on her hostage to hero approach to jury selection and working up cases. So it's just so many different things to choose from. And beyond that, though, there's stuff to do on Wednesday, October 16th, like Claggett Sykes is having a golf outing at Bally High, which you'll probably be at if you're there, because I know it's a scramble, so everybody can play. And then Nick Rowley's taking a bunch of people out to the Red Rock Canyons to do some hiking. And my buddy Kurt Zahner's going to take a group of people out to the desert and, rent dune buggies and ATVs and do a little adventure stuff. So there's just that kind of stuff. And then at the conference itself, we have theme parties every night. I know you're a big themer, Rahul. So we got an 80s party. So is Panish. I can't wait to see Panish in his 80s outfit. If I ever see anything Panish except a coat and tie at a conference, I'd be surprised. But we're going to work on getting him to relax a little bit more. But we're going to have an 80s party on Thursday night, a Halloween party with a live band karaoke. And I've really got some great musical acts because I go and see them now before we hire them. So I know what kind of energy they're bringing. And then Saturday night, we're going to have a beach party theme because, of course, we have to get people psychologically ready for the summer, 8 months down the road. Most people have to go home to the cold. Not you, but most people are going back to the east and the north. And so they'll be looking forward to June, summertime, back at the Paseo. But before we get to Vegas, we're going to do some more teaching virtually on, webinars, which is how we met originally through the pandemic. And I know we're going to have 2 of them planned. So can you tell us the dates that you've picked for those and the cases that we're going to be breaking down so that we can plan our schedules accordingly?
Yeah. So August 21st, we're going to do a webinar on a trial I had last year, Greener versus Del Mar Jiu-Jitsu Club, where my 21-year-old white belt student was sparring with his black belt instructor at the end of an hour-long class for a couple of minutes. And the black belt instructor did an unbelievably wrong move on my client and then rendered him an incomplete quadriplegic. And so the trial involved, assumption of risk issues. There were waivers and how we navigated through that. And then ultimately, we ended up with a little over a $46 million verdict on the case. So I'm going to talk about where we started, and we're going to talk about all of the work that we did, which was a lot of work to get ourselves prepared to deal with all of the issues in the case. The voir dire process in a case like that, involving assumption of risk type arguments, and the cross-examination of some of the key defendants and their witnesses, and how we got to the finish line on it. And I really have become a huge fan in arguments in cases where there's comparative fault or difficult liability type arguments of at least contemplating these divergent timelines. And Dan, I know you've seen some of them, but the important thing for me in opening statement is to do some teaching, hopefully gain some credibility, and avoid delving into really any meaningful argument. So that teaching component is part of our divergent timeline in developing what the best practices or appropriate practices are for somebody in that industry. And then the divergence is what ended up happening in this particular case. And so I'll teach you about these divergent timelines. Some of my friends have used them in some of their other trials, like Brian Beecher used it in his case against Walmart and got a very good verdict. So it is an incredibly effective tool, and it is something that I think helps develop that discipline of getting to the universal and irrefutable truths in a case. So I'll teach about that during that. And then on September 12th, we're going to talk about a case is Sherwood versus Speed Vegas. It was a Nevada case. Trial started. Some witnesses were put on after opening statement before the case resolved. This is a case that happened at one of those tracks in Vegas where you can go if you're a vacationer and drive exotic cars. And this real estate agent from Canada went to Speed Vegas, got in a Lamborghini with a professional instructor in the passenger seat, was on the straightaway going about 130, 140 miles an hour. And then it goes into an S-turn and he lost control of the Lamborghini. It hits a sidewall and then gets engulfed in flames, and both of them die. And so I think you're seeing a theme here, Dan. This is going to involve some assumption of risk issues and things like that. And I can explain exactly how we got from where the defense thought this was a zero liability case to them ultimately paying what they confidentially had to pay.
And at that trial, I was there for the opening statements, and it was recorded, and it was on CVN, whatever. As much as you got through, it's all on CVN. Yep. So that was, stickly remember that, because that was kind of cool. Because I think that's the first time I actually saw you in trial, and hopefully you and Padish have a few more trials coming up here.
Oh, yeah.
The next few months, so that, because I have this idea, because you learn so much in trial, but like to have, when possible, especially after Vegas, trials you have after Vegas, to come out there and really be part of, just like in the, like a trial watcher with a group of people, because I think we learn so much by watching the trial and seeing the trial and just communicating with the trial lawyers too, because there's so much going on in there. So I think that's going to be really great. And if people can't tune in live to your webinars, they are going to be on TLU on demand, which, is really coming along well. And I'm pretty stoked about it because, we not just have the webinars, but we have all the live conferences on there too. And we collect all the pleadings, transcripts, and PowerPoints for these cases. And I'm building a tool, which is almost done with AI, which is going to transcribe and index all of these videos with the PowerPoints and slides built into them. So it's going to be extremely searchable, and it's an app for the phone now too. So that way, folks can learn anytime, anywhere, and more specifically too. Because the great thing about the TLU on demand is that, you really retain stuff when you're working on a particular case. You're working on a slip and fall case. Well, if you listen or read about other people's slip and fall verdicts, or how they did things and how they did the comparative fault, how they did damages on your particular case, I think it's very sticky. Whereas if you're working on a products case, you listen to slip and fall, well, it's not going to really, you might find interesting stuff, but it's not very sticky. And so that's really the beauty of it too, is that the information is there when it's neat, when you have the biggest need for it.
Oh, that's fantastic. I can't wait to see that AI component of it.
It's almost done, and like that's such a transformation, because the regional thing now gives a really good summary of what it's about, instead of what remember you little summary of what it's, you write a summary, but that's pretty but it's before it's done, right? But after it's done, or else to search for experts or to particular witnesses or see like jury empowerment and closing argument and watch 10 great lawyers do it or hear about how they did it, I think is really helpful.
So does
It
it
would be for me.
scroll the text with does the PowerPoint presentation, if there is one, scroll with the text? So
Yeah,
like
it's in there in the space where it's at. So that was like another tool that was built. So
nice.
I'm looking forward to see it. And then we put it out there and get some feedback and kind of keep on working on improving the user experience on it. So it just becomes more valuable for people because there's a lot of learning to do to become a great trial lawyer. And you got to be working at it all the time if you really want to, get to the top. But now I think we say this is the greatest time to become a trial lawyer because everything's available now. All that information is there. And and it wasn't before because people like the pandemic, I think really got people to teach much more intentionally and share much more. And so it's like, if you don't want to become great, that's your choice now. But at least it's a choice. Before it was, because the mentorship thing is challenging too. Because, you had Brian and all those great lawyers you got to be with that really helped you propel your career. But most of us have nobody. And so it's really hard to learn. And you learn by trial and error. It can be really expensive. It could bankrupt you before you learn the lessons you need to become a winner. But actually, you teach a lot, and you've mentored a lot of young lawyers. So let me ask you, if somebody came to you and said, Rahul, I really want to become a great lawyer, but I'm just lost and confused. And I don't even know where to get started because there's so much. And you said what things you take pride in is building trial lawyers. So what advice would you give to a young person? Maybe it's just the beginning of their career or maybe even in law school. Let's say some of these law students come up to you and like, Mr. Ravipudi, what should I do? So what would you tell them to do if they really want to become trial lawyers?
Well, if they really wanted to become a plaintiff trial lawyer, not just get into the trial lawyer space, I would tell them that they need to first start to get into the organizations. Here in Southern California, I'd tell them to join CALA, Consumer Attorneys Association of Los Angeles, because that's got over 4,000 members, and almost every plaintiff lawyer in Southern California is a member of CALA. And so you're going to get an opportunity to meet a lot of people. I tell them to go to productive trial education seminars, and obviously TLU would be at the top of that list. If they could actually afford and join your website, then they should do that too. And I think you make it available free for law students, or kind of free, Dan. Is that right?
$17. It's a couple cups of coffee. You gotta have to pay something.
Yeah.
And at least they remind them every month, hey, I just paid $17. I better go watch some videos. I better go learn something, or else I'm just pissing money away.
Yeah. And then the other thing is, and this is where you and I became friends and started talking a lot about how to spread education. I mean, our firm, we created our own psrplaybook.com. And if you go to that, if you're a plaintiff lawyer or in the plaintiff field only, you're able to sign up for that and then have content that we've been creating as well. And so there's, to your point, Dan, there's opportunities to learn for those that are interested. And then from that comes really, I think, the most important thing. And, I'm not even close to unique in saying this, but there really is a need to be authentic and true to yourself. And so, for example, I've learned so much from Brian, but I've also learned I'm not trying to be Brian because there's no way I can do that. He's got his own personality and his own presentation style. And if I tried to do that, I would be a very, very bad trial lawyer. And so what I need to do for myself is learn these different tools, these different approaches, these different ways of questioning that fit with my style and implement it in the best way possible. And so getting exposed to a number of different lawyers that you know and respect, hopefully you connect with some that are more like your style, and then you're going to be able to learn more faster, and then also sprinkle in some people that maybe have different styles so and learn and appreciate what makes them so effective, and then you can still pull in some strategies from them as well. But it's like, to your point, Dan, back in the day, not that long ago, you only got what was available to you. And what was available to you may not have even been helpful to you. And so now you've got an availability to every good lawyer across the country. So there's no shortage of access.
Yep, and everything that we're doing at every conference is always recorded and shortly put up on TLU on demand. So because that way people put so much effort into these presentations that would be, to me, it would be a sin if they were only seen one time. But the fact that that all that effort you put in, the folks that are there can learn from it. But then future trialers, future generations of 5 years from now, 10 years from now, people will be watching these presentations that are being done at TLU or done on these webinars and learning from them still, just like they're learning from stuff that we did 3 years ago. I still look back on some of the, some of those early productions we did when I was just trying to figure out I was trying to figure it all out. So it takes a lot to figure out to be a good host, to be able to help, the trial lawyers tell the story of what's going on. It just takes practice. And the top of all the strategy and stuff, I've developed a program on presentation, controlling all the, because it takes a lot to become a good presenter, and you don't get that much time in the courtroom these days. And when you get that time, you want to make the most of it. Because you get that time, you get there, you want to, you got to hit it out of the park. And, so the stuff that I teach about eye contact, voice control, hand movement, facial expression, I think is extremely valuable. And it's such a great, there's no greater thrill than getting an email from somebody that you helped. Like this guy, his last name's Elder, first name's like Azam Elder from Detroit, just sent me an email the other day about his first civil rights case and watching Dale Gallipo and learning from him. And he got a $9.5 million verdict on this guy that got a broken leg from the cops. And he was just so ecstatic. And you know what I mean? Because it's like, you got justice, you got some healing for that person, and you've got the feeling of being a winner, and you made money, which is, let's be honest, if you're not making money, you can't do the work because it costs a lot of money to do everything, and it's part of what part of why we do it. I mean, we got to get paid. So Rahul, I want now to shift this over to really just talk about trial strategy, and you just talked about the young man who got terribly injured at the karate place, and so let's talk about the case a little bit. I know we're going to do a case analysis on it, but I want to know, what do you do in the 90 days before trial to really help you and the team that you're trying with to get ready to step into that courtroom and, say, good morning, everybody. And my name is Rahul Ravipudi, whatever it is, to start the trial. Give us some of the processes at your firm.
Yeah, in this case, we co-counseled with another firm, and Sean Morris and his team. And then we had Paul Trina, John Schaller, and Trevor Weitzenberg from my firm. And so we were not short of resources to get prepared for this case, which was all needed. And the first place we started, especially on a case like this, is I wanted to know, what are everybody's concerns? And then we started to compile everybody's concerns. And it added a lot of mine and saying, okay, is the defense going to argue this? Is this piece of evidence relevant or admissible? And as we started to get through it all, we identified those concerns. And then the next question is, well, what are we going to do about it, right? And so for some of it, by way of example, without bearing the lead, one of them was the waiver. An express waiver in California elevates the case to a gross negligence standard. And as you have 7 people looking at this waiver, the first question is, well, does it apply? And if you're just going to take it at first blush, maybe the first question is, did our client even sign it, right? We got past that issue. He definitely signed it. And so now we need to look at, does it apply? And then we got to figure out, well, what's the standard here? You got to go under contract principles and under adhesion contract principles. And as we started to navigate and get through that, what was a divided room on whether it applied came to a universal and unanimous opinion that it was an unenforceable waiver. And we teed up the motion and got that all worked up and filed it and prevailed on that. So identifying these issues, I wish I could say that just took 20 minutes and we just said, hey, this is how it's going to be. But really, there's an exercise in getting us all on the same page to start. and then getting us rowing in the same direction to put together some amazing work product that gets us to the final destination of actually winning on what I think are significant issues, whether we have to try this case on a gross negligence standard versus, the lesser standards. So those are some of the things that we're going through. And then this is the hard part, because I wish all these motions were heard, 4 months in advance. And then I know what the playing field is, because then I'm going to know, okay, I can start working on my opening statement right now. But I don't know what the ruling's going to be on my objections to deposition testimony that's designated. I don't know which experts are going to survive motions in limine and whether we're going to get some excluded. I don't know whether I'm going to have to still try this case on a gross negligence standard. And so a lot of these pieces are in flux, and we're building out the modules of, okay, if I lose this issue, this is how we're going to frame it. If I win this issue, this is how we're going to frame it. And then taking that tree diagram all the way down to its very bottom, you've got a lot of variables in place. And, for me, I like to be prepared. I get that sometimes I got to think on my feet, but I think I'm better thinking on my feet when I'm actually prepared on the issues, right? So, and I think that's true on everything, including cross-examination. You're a better cross-examiner if you're actually prepared on all the issues and know all the evidence. And, there's some basic skills that everybody can or may have, but that only gets you so far, and I want to get to the finish line. So my 90-day lead up to trial is pretty labor intensive, and I'm sure a lot of people would complain about it, but it's like training for a marathon. You don't really probably enjoy doing the process, but you enjoy the result. So then it gets into the next step, which is we work closely with trial techs, because we have a lot of deposition testimony that we want to use in different ways. And I need to understand how the judge is going to function and whether that judge is going to let me use it in the way that I believe the law allows me to use it, or am I going to be restricted in certain ways? As I start to understand that, then I'm building in certain pieces of testimony into my opening statements, and identifying and seeing how it all plays out. Sometimes the questions are asked multiple times, and I like one version more than another in that same transcript. And so you just got to go through the exercise of looking through the testimony to really understand what I want and what we want and what we don't want. And then, then it's starting to build out the examination outlines for each of the witnesses and trying to figure out how are we going to cross-examine these people, especially on the key ones. For example, the instructor who did it, we did maybe 10 or 15 mock cross-examinations. And the way we did it is the best way, which is having a lawyer play the witness, a lawyer who knows the facts and knows how to play the game and tries to be evasive and tries to do everything. And then we start to refine the cross-examination to the point where it gets to my theme, which is universal or irrefutable truths, where all that witness could do would say yes. And ultimately, through that sort of practice, that's what unfolded at trial. And liability was established after I put on my first witness. And so those are some of the things that we go through in preparing a case for trial. And I go through that very similar exercise in different versions of it, depending on the case, every time I'm preparing for trial.
Okay, in California and in some states, the first part is the mini opening. And so tell us about what your philosophy is on mini opening and how you went about it in this case.
Yeah, so mini opening is an opportunity for us to very briefly inform the panel about the nature of the case. And the mini opening it takes over sort of a joint statement of the case, which in this case, would have said something like, on this day of November, Jack Greener was a student at Del Mar Jiu-Jitsu Club. Plaintiff complains that Mr. Iturralde, the instructor, performed a technique on him that increased the risk inherent in the activity and resulted in injuries. And defendant denies they did anything wrong and denies the amount plaintiff is asking for in damages. Great. That doesn't tell anybody anything, And so now I get to go into voir dire, and they're like, I don't even understand the case. I don't understand what you're asking for. I don't understand why they're wrong and you're right. I've got no context. And so since I have no context as a prospective juror, I can't tell you about my biases and prejudices. And if I don't get that information, I'm going to have a jury of 12 and have no idea if some of them are ticking time bombs. So my job is for my client. And for my client, I'm not trying to win mini opening and prove my case. My whole philosophy, and Sonia Chopra and I do this, is jury deselection. And so what the framing of our opening statement, mini opening, is one where we're trying to identify through an accurate recitation of the facts, but not in a plaintiff advocacy sort of way, touching upon maybe 3 to 5 facts which may trigger people's feelings and biases so that they can communicate to them to us. Half of them usually have to do with damages as we lay out what the types of damages we're seeking, and then the non-economic damages. And I always say each of the elements of non-economic damages: the pain, suffering, emotional distress, mental anguish, disfigurement, loss of enjoyment of life, inconvenience, anxiety, humiliation. And we're going to seek a dollar figure and ask for compensation for the experience of each of those things in an amount in excess of. So that is always going to be, or is oftentimes, a part of our mini opening statements, just to tee up the issue, because sometimes jurors have issues with pain and suffering. And, everybody lives through pain. And I've heard a lot of prospective jurors say, there's a lot of people who live through pain. There's, my family member was in the military and suffered an injury in war. They don't come to the courtroom and ask for money for pain. So I get the emotional distress, mental anguish, disfigurement, loss of enjoyment of life, humiliation, anxiety. I just don't like pain. And I don't think I could ever award any money for pain. Those are the things, and distilling it at that level that you start to understand. And candidly, a lot of the people that say they have issues based on their life experiences with pain really do have issues with every other element of non-economic damages. So, I appreciate as much as they're willing to share, but the reality is that, and then I'm able to identify whether we want to exercise cause challenges on them. Here with the assumption of risk, Jack Greener chose to go to the Del Mar Jiu-Jitsu Club, and he chose to take a class with Mr. Iturralde, and he chose to spar with him for a couple of minutes. And because the question that I'm going to ask in voir dire is, how many folks through their life experiences have chosen to do a risky activity, and because they chose to do that, don't feel like anybody else should be responsible if they get hurt? And then all these hands come up, right? Because we've first talked about it in our mini opening statement. And now these folks are going to raise their hand and say, I went skydiving, and if something bad happened, that's on me. Some other people would say the exact opposite. I went skydiving, my parachute doesn't work. Goddamn right, I'm going to be suing that, that company. But it's good to know, and you're starting to frame these questions in the first of all, it's okay to have these feelings. I've heard a lot of people say this, normalizing the negative so that they're explaining their negative experiences and how that translates to their biases on the plaintiff side of the case. And my job is not to do the defense lawyer's job. If he or she wants to do it and wants to identify biased jurors, they should do that for themselves. But I'm not in the practice of helping them do their job. If they choose not to, that's on them too. But that's part of our process, and that's what we did in this particular case. And there were so many people who just said, yeah, he chose to take the class. Sorry, I can't even see any liability in a case like this. And all of those people got excused for cause, not just because they said it, but because they said it based on their life experiences, and that was something that was going to be on their mind if they were a juror on this case.
Let's take a look at the voir dire in this case. And I really want to understand your approach to voir dire. And how do you get started when you stand up?
So I normally, and it depends case to case. In this particular case, during mini opening statement, my client Jack Greener was there. And then after when I started with my voir dire, he wasn't there. And so I always start and I introduce myself to the jury and I tell them who I have the privilege of getting to represent. And then I talk about what our exercise is here right now. This is my only chance to get to talk to you, and actually have a conversation with you and get to know you. Because after this, we go to the next stage of trial, which is opening statement, where I get to talk at you. We don't get to have a conversation. And then then the next phase is putting witnesses on the stand. And I may not even be looking at you. So I'm going to be looking at the witness, and then you're going to be looking at the witness or me or whoever else. And we're not even going to have any interaction. And then closing argument, where I get to talk at you, but we don't get to talk. And then the next time I may get to speak with you is after the verdict, if you take the time to speak with me. So I always think of this, I didn't get to do this before I got married, but I always think of this exercise a little bit like speed dating, where I don't get a lot of time with you, but you're going to bare your soul to me in the 2 to 3 minutes you have. And then between the two of us, we're going to look at each other and say, hey, we've got this connection. I'm going to be part of this trial. Or what happens mostly in speed dating, and that's why there's a lot of people in this room, you may look at me and say, hey, it's been great knowing you, but we're not going to make it to the next phase of our relationship, which is opening statement, and that's okay, right? And then I start to explain, and I love Keith Mitnick's example to explain biases and apple and cherry pies. I always use lemon cake and carrot cake because I actually don't like lemon cake, but I think it actually illustrates the example perfectly of what a bias is, which is something that's on your mind. I don't need a visceral reaction in order to exercise bias. Warning, a cause challenge. If I eat lemon cake, I'm not going to throw up. I'm not going to cause a fist fight if somebody gives me lemon cake and shoves it down my throat. I just don't like it, And if I don't like it, I'm going to look at a menu. I ain't picking the lemon cake, and that's it. And so it's always going to be on my mind, and that's why, like as Keith says, all things being equal, lemon cake's going to lose, even if it's made just as good as that carrot cake. And trying to switch that into the issue of lenses, and that life experience that I have with lemon cake, that's the lens at which I'm going to see everything. And it's okay for us to have those types of biases. And what's most important is that you actually communicate it to us. And you're fulfilling your civic duty and responsibility just as much, if not more so, by telling us right now that you cannot be a fair juror on this case, rather than concealing that and allowing injustice to happen. So that's not exactly my spiel, but those are parts of the themes that we get into. And then I'll always start with some sort of softball issue of, just the concept of burden of proof and the lesser standard in a civil case, and the fact that I'm seeking such significant compensation for my client. Does anybody here think that I should be held to a higher standard? And sometimes I get conversation going from that. Sometimes I may have to ask individuals on that issue, because it's the first question out of the gate. And so I'm trying to get a little bit comfortable with the room and understand what type of people I have that I'm interacting with. And I'm also hoping that I'm able to get somebody to just start talking. And usually a pretty hostile juror is ready to rear her or his head sooner rather than later. And then I'm able to start hitting a bunch of the themes that I brought up in my mini opening statement with that prospective juror. Yeah, I think you should have a higher burden of proof. If you're asking for $50, I'm good with this, standard of more likely true than not. But once you get up to $50 million, it better be beyond a reasonable doubt, even higher than that. And then we start to kind of unpackage that. And really what they're saying is, this is, a different way of a tort reformer saying that, hey, I've got issues with, the amount of damages being sought. And that shouldn't be a standard. And then we start to get to their biases and life experiences that led to that. And then that same person, if they're so vocal, they'll be like, and by the way, your guy chose to go do jiu-jitsu. And then we get into the assumption of risk issues. And so I'll establish a cause challenge on maybe 4 or 5 different reasons. And that makes them non-rehabable in the first place. But it also then I say, does anybody else share the feelings of juror number 5? And then, 12 more hands go up. And then we go through them and it starts to become more efficient. I agree with juror number 5 on issues 1, 3, and 5. Okay, so let's just break those down. If you can't be entirely impartial on this, not on that, what are your life experiences and bases for that? Nothing's going to change your mind. And then we go to the next juror, and then it just kind of goes in lockstep. And after about 4 days, I ultimately end up with 12 jurors and 4 alternates, and get a jury that at least has promised that they can be entirely impartial, hear the evidence, and if the evidence supports it, award damages in the amount I'm seeking for.
How'd you talk about? I assume you had to talk about comparative fault in this case.
No. So the defense was going for a defense verdict. The strategy, as I understood it from the defense, is conceding or arguing comparative fault on a white belt would be conceding fault on their own client, the black belt. And so they thought it was like a double-edged sword to even go down that path. And they really wanted to target just assumption of risk. Too bad, so sad. Shit happens.
Did you talk about the waiver in voir dire?
Oh yeah, I didn't talk about it. It was talked about. So every juror's like, I assume your client signed a waiver, and if he signed a waiver, and it got so pervasive that the court had to intervene and gave an instruction that the waiver, the existence of it, the non-existence of it, it is not evidence in this case, and it is not to ever be considered. And then you'd see all these heads nodding. Okay, got it. And then the next person, so was there a waiver? Right? And we thought, oh, geez. And that's not fun to hear from the plaintiff's side, but it's a reality. And then even during the trial, question from the jury, so are we going to see a waiver, right? And then the judge would have to instruct them, okay, guys, waiver is not evidence in the case and is not an issue for you to consider. Be like, okay.
But if the client signed a waiver, how come it wasn't an issue in the case?
So a waiver it goes under contract law, right? And so if you're waiving certain rights, they have to be expressly identified and waived. The waiver here, the Del Mar Jiu-Jitsu Club just downloaded something off of Google, and it was a waiver for a child that a parent's supposed to sign. It's a single event waiver, and it wasn't signed on the date of the incident. And it actually did not release the instructor who, because the Del Mar Jiu-Jitsu Club did business in a certain way, hired him as an independent contractor. And so for 3 separate reasons, the waiver was deemed unenforceable in the case. So yeah, there's a waiver. Yeah, he signed something. It just happens to be unenforceable. And so for that reason, the waiver was not something that was going to get put in front of a jury. Also, under California law, if the waiver was deemed enforceable, it still would not be evidence in the trial. The court would just say, I found the waiver to be enforceable, and so now your standard is the gross negligence standard, and you have to operate under those jury instructions. So under no circumstances would a waiver ever make it into a trial, unless the argument is that the waiver is ambiguous, and so the defense would have to make that argument, and they were not proffering it as an ambiguous document while we were arguing the motions.
All right, let's move on to opening statement. In the opening statement, tell us about your approach to it, and if you talk about the money, you talk about your client's injuries, and how you talk about it, and how you just kind of put this opening together, and your visual strategy.
Yeah, so in our opening statement, and this case seemed to lend itself perfectly to that divergent timeline we were talking about. And so what I was explaining to the jury in sort of a narrative and teaching way was just, what is Brazilian Jiu-Jitsu? What does that mean? And how did it come about? The importance of bringing up how it came about is because the expert witness we hired in the case was Henner Gracie, who is part of the Gracie family, who were the founders of Brazilian Jiu-Jitsu. And Henner had never testified as an expert in court, but has taught over 100,000 students over his career and through the Gracie Academy, and is a very dynamic individual. And so, so introducing the jury to some of the people that were involved. In a case like this, and I have different philosophies based on different cases, but in this one, I felt like it was not appropriate for me to try to garner sympathy for my client on the front end and talk about the nature or severity of his injuries. And rather, I thought it would be a better time for me to teach the jury about Brazilian Jiu-Jitsu, how these classes work, and what best practices are. And so I taught in a 4-square format about 4 things a Brazilian Jiu-Jitsu instructor should do to ensure the safety of their students. And if they're engaging in any practice with any students, white belt or not, that they need to first be aware of their students' proficiencies. They need to teach techniques that, when executed incorrectly, do not result in paralysis or death. I feel like that's a reasonable concept, and the experts supported that. And then when you're teaching the move on your students who have no experience with it, you need to teach it while having total control over your student, right? They don't know where they're supposed to be, so you should be having control over them. This is not a competition. This is practice. So if you can't have control over your student to execute the move in a way that doesn't break their neck or kill them, then you shouldn't do it. And you should have total control over yourself as an instructor when you're engaging with your students. So those were my 4 concepts. And in this particular case, none of that happened. And then it switches to Mr. Iturralde did not take into consideration the skill level of his student, Jack Greener. Did not take into consideration, he's taught a move and executed a move that had a risk, a significant risk of neck injuries, paralysis, or death. And when he decided to execute on this technique, the undisputed evidence is he had no control over Jack Greener. And tragically, by choice, Mr. Iturralde had no control over himself at the time he executed the technique. The result, and then we start going into the injuries and started talking about that. With those 8 concepts, the 4 teaching, and then shifting, and then I have all the evidence, and I have deposition clips from the defendants and their experts agreeing with all of that. So these are all irrefutable facts. And then with the divergence and the failure, all deposition testimony and experts on that, showing that the admissions that this is indeed what happened. So by the time I'm done, hopefully with my first part of the teaching component, when I show what didn't happen, I hope the jury's almost finishing my sentences for me, like, oh, you got to have control over yourself. You got to not teach a move where you're going to break people's heads and necks. Because, if you have a white belt and you teach them a move where if it's not done precisely right, they could screw up, they're going to screw up, and then you're going to have a bunch of white belts with broken necks, right? So it's common sense, but laying it out in this way kind of flows with the actual evidence in the case. And then we started. Yeah, go ahead.
Did you talk about the number, how much money you're looking for in opening?
We talked about it in mini opening, and then talked about that in opening statement as well, and walked through the life care plan, the cost of the medical expenses, the loss of earning capacity, and then finished very briefly with the pain, suffering, emotional distress, and that we were seeking in excess of, I forgot right now, I think I said 70 million.
Got it. So order of proof, proving your case. Tell us in this, your philosophy on, witness sequencing and who you let off with in this case.
I let off with the instructor in this case. And I'll just say, it pays dividends when you do an opening statement and you've got it organized in this way with these irrefutable truths. because I'll tell you what the defense lawyer said in his opening statement after he started through part of his spiel. And he goes, and Mr. Ravipudi, you know, he put up all those boxes with all these things that you're supposed to do and stuff. Mr. Iturralde, he'll check off all those boxes. So first witness up, Mr. Iturralde. Hey, you heard your lawyer. You're sitting here in opening statement. Yeah. He said you're going to check off all these boxes. So let's just go through them. So I read them. Do you agree with this? Yes. Do you agree with this? Yes. Do you agree with this? Yeah. Okay, let's get to the next spot. You didn't do this. No. You didn't have control over Mr. Greener. No. There was a risk of paralysis or death with the technique you did. Yes. You didn't even have control over yourself. No. So within 90 minutes of cross-examination, not only did I get very direct confessions, which proved my case, then I layered on it all of the other issues, which is he'd do this same technique on a 7-year-old kid. He'd do it on an 80-year-old man, and he has no apologies for what he did. He'd do it again. There's nothing he'd change. And so he was the first one out of the starting gate, and it went very, very well.
And so I know you didn't get through the whole trial, but, you know, as far as the plaintiff and his family, where'd you put them in the list of things, and how do you kind of sequence, you know, liability and damages? Because they still continue to deny all liability, right? That's what the guy had to say. I did nothing wrong. I'd do it all over again.
Yeah.
So sorry. No, right. Because if he says I would do it differently, then they'd be admitting liability.
Yep.
From the get-go.
Yep.
All right. But just your general philosophy on, you know, the sequencing and timing of witnesses. I know a lot of people, like you just did, like start with the defendant, you know, punch him, hit, you know, they prove the case through them, but where do we go from there? Sequencing.
Then I continue with more liability, usually the defense witnesses, which is what we did in this case, and then start to overlay a little bit of the damages. The injuries here are also not really in dispute. I mean, he's an incomplete quadriplegic, and so nothing's going to change on that. So starting to bring in the neurosurgeon, retained experts on that, and start to explain the medicine behind how Jack is the way he is and how he's not going to get better. And that type of evidence came in so well. And, you know, when you start to put on all this evidence and you just put it on in a very straightforward way, we did some demonstratives. And one of the things that we did was just start to explain the examinations that were done. And we had one of the lawyers on the team sit with our neurosurgeon expert and then explain, and had Jack there too, and kind of explain, you know, pincer grip. You know, okay, if you go to Jack and I just put my finger through, had him put his index finger and his thumb together, I could easily swipe my finger right through it, as opposed to somebody else, and you can't get through it. Just these simple concepts to explain how the spinal cord was injured, how my client can still stand with assistive devices and orthotics and things like that, but he's not like unable to do anything from the throat down. And so illustrating all of those things to the jury, and then starting to then explain how that's really impacting his life on a daily basis. My client, Jack, he was in despair. And, you know, when you have a spinal cord injury like this, and you're young, and you're somebody who is going to be a professional surf instructor in Costa Rica 3 weeks later, had this injury not happened, you know, his whole life's ahead of him, and he was excited, and he now couldn't do any of that stuff, and was incredibly depressed, significant suicidal ideations. And the way he balanced it was he would try to do activities, rock climbing, things like this, all adaptive, and then he would have it all on Instagram. So the largest exhibit binders in this case were his Instagram files. And the defense wanted to use that to say he's fine, right? Look at him doing this, look at him doing that, look at him doing all these things. And so we needed to take that head on and put context to all of this Instagram stuff that's being posted, and put context to why he's even posting so much on Instagram. And it was really to save his own life. So by the time we were done putting that on through mom, dad, friends, one of the friends, they had a documentary done of Jack Greener, and it was done because he climbed Mount Whitney. I don't know, have you climbed Mount Whitney, Dan? It's not easy to do. I haven't done it. Jack has done it as an incomplete quadriplegic. And so the defense obviously wants to extrapolate on that and so he's fine, right? So we had his nurse who joined Jack on this adventure. He testified about all of the trials, tribulations. Poor guy, just trying to urinate, and then he falls off a cliff, and, because he can't keep his balance, and all of the different times he's fallen just because he's taking one step further, and he walks kind of like Frankenstein. And everything in context brings the truth back to the jury, which is this is a guy who's trying to do the best he can, and he needs a lot of help, and it's not okay, and he's not okay. So by the time Jack took the stand, he was one of our last witnesses, and I felt like the jury already kind of knew him, and then got to know him a lot better through his testimony. And Jack talked a lot about his suicide beliefs, and it was uncomfortable, but it was the reality of what he was living through, and the jury, I believe, wanted to and needed to hear that. And so all of that kind of came out through his testimony, and the defense did what they did, which was look at all your Instagram photos. Look, here's you rock climbing here. Man, you've gone on more vacations than I've gone on, and, I'm so sorry your girlfriend left you because of your disability, but don't you feel like you're better off knowing that now than later on down the road? Stuff like that, and I don't think those types of things make points on a true catastrophic injury case like this, but you do what you do. So
cross-examination and of experts, really. What kind of experts do they bring in this case, and how did you go about crossing them?
Neurosurgeons, life care planners, orthopedics, pain management doctors. There's a lot of experts on a spinal cord injury case. And so the cross-examination of a lot of their experts really was walking through a lot of their concessions. And it's very hard on a case like this for a defense expert to come in and say, he's fine. Really the only fight is, does he need these adaptive devices? Is he going to get any better? Obviously not. Is he at a risk of being wheelchair bound for the rest of his life? Of course he is. And so the cross-examinations were short, and they kind of got to the point. And really the big fights were on some of the economic issues, like the life care planner. And the life care planner for the defense hadn't testified very much, and she was a lawyer and just kind of got a little bit aggressive. So,
she's a life care planner, a lawyer?
Yeah, she went and got her JD, and she knows better than everybody. And so
she was a life care planner first, then she thought she'd go get a lawyer so that way she'd be like have more credibility or something stupid like that.
Yeah.
Okay.
And but really sometimes what you want to do with some of these issues is just get the key concessions, and they may not even make a lot of sense at the time, but they give me what I need to then put it into the closing argument. And so with a couple of the experts, it was pretty straightforward. With a couple of them, it may have seemed a little bit more subtle, but they weren't exciting for the defense when they put them up. And there was nothing exciting on some of the cross-examination other than accomplishing what the truth is, which is Jack is gravely injured and will be injured for the rest of his life, and things are only going to get worse for him with every passing day.
I assume you have a lot of impeachments with. Can you think of any good reason not to videotape a deposition?
No.
Other than you don't have the money, and if you don't have the money, you should get it. But I just because, can you give us an idea, this kind of case, what it costs you to litigate these things, a case like this?
It was just shy of $1 million through verdict.
Wow.
So $960,000 or something like that. I'll have to double check.
Right. Yeah, I'm just curious because, I know some of these cases are so expensive to litigate, and obviously a firm like yours has the resources, but there's so many people that they could even consider doing this case without bringing in a firm like yours. But like today, it's kind of cool because for lawyers who, don't have the history and the bank account, there's companies like, HMR Servicing and stuff that can provide, the funding to make sure that all this stuff happens, because it just costs an insane amount of money. Closing argument, when you think about it, what do you, when somebody said, hey, Rahul, what are your best tips on closing and some of the stuff you put in on this case? Tell us how you start off on closing. And do you ever practice your closing before you give it?
That's a great question, Dan. Sometimes I do, sometimes I don't. And it really just depends. But by the time this is just for me, and I would never suggest that there's no need to practice. Sometimes there's just time components associated with that too. But by the time I'm at closing argument, I've seen how the whole case unfolds. We know I've lived every moment of it. The jury's lived every moment of it. And so it's more about just making sure I'm getting the message across in the right way than it is actually trying to make my points. Do you know what I mean? Because everybody's heard all the evidence. Now I just want to make sure they understand what the relevance of it is, and the jury instructions start to come into play. And so the two of the most important things to me are making sure I get to explain to the jury the salient jury instructions that they need to be considering, understanding what the verdict form is, and taking myself back away from my opening statement. Because in my opening statement, it could be a lot of people's, with just a little tweak in rhetoric, it could be a closing argument. But I don't find it to be the best practice to say, remember what I told you in opening statement. Now you heard all the evidence that I told you were going to hear, and let me just walk through it all for you again and just do my opening statement with a little bit more advocacy involved in it. So kind of rejiggering everything to then get my messages across on both liability, responsibility, the irrefutable evidence in this case, how it applies to the law, and then more importantly, get into the damage side of things and articulating to the jury and spending a lot of time with them so that they understand why I'm asking for what I'm asking for, and that it is not just because I don't have a bill or an invoice associated with a amount of compensation doesn't mean I'm lacking evidence, and that I'm the only one who's presented overwhelming evidence on the pain, suffering, emotional distress. And then I'll juxtapose it with each element and explain, here's all the evidence on pain. Here's all the evidence on emotional distress, mental anguish, disfigurement. Here's his life expectancy. Here's what he's going to live for. And here's what he's going to live with. And here's how his life's going to go. And as we go through that, depending on the case, I may reduce it and explain, so, this is the compensation for this element per day, per hour, per year, just the whole number. But I kind of walk through my thought process and what the best messaging is depending on the jury and depending on the trial.
I forgot to ask you, your client's presence in trial. When do you have your client there?
That depends, but in this particular case, he was there for voir dire for the very first part, and then the next time he returned were when my medical experts were on the stand, and then he wanted to be there when his mom testified, and then he came when he testified, and then he was there for a closing argument.
Okay.
Yeah.
And I'm just curious, what did the defense say in their closing in this case?
The same thing they said in their opening statement, which is, Jiu-Jitsu is a very violent sport. This isn't Tai Chi in the park where you sit there and you just hum different words. It's a very physical, violent activity, and bad things happen. And people get trained and are training for competition and are training to, for unpredictable circumstances, and that's just the reality of the activity. And so, and that's what happened at the time here. This was a technique that Mr. Everalde has done in different forms at different times, and it's an unfortunate consequence what happened to Mr. Greener, but it's part of the sport, and sorry, this should be a defense verdict. And by the way, plaintiffs just pulled out of thin air some number of 70-something million dollars. So if you get to this question, $1 million. How'd I come up with that? I don't know. Same way the plaintiffs came up with their number, right? And then kind of was very dismissive of sort of the process of putting evidence to a number, and just kind of put that $1 million number up there. And I think in total with the economics, it would have been like 2.2 million, or I'd have to check, but some sort of low number. And then ended it that way. But it was about a 45-minute closing argument, aggressive, and, took some swipes at Jack, and took some swipes at the experts, and then...
No swipes at you?
No, I don't think he did.
He's such a nice guy. People can't swipe at you.
No, and he's tried a lot of cases. He's a good lawyer, so he knows his way around the courtroom, and was an effective advocate for his client. It's just, the facts are the facts in a case like this, and you just gotta, as the plaintiff lawyer, I just really, really, a lot of people didn't like this case, right? And you get presented with it, and I think it's just, again, the initial reaction people have is, I don't know if I want to deal with an assumption of risk case. I don't know if I want to deal with a complex product liability case. I don't know if I want to deal with this, but when you're able to distill it back down to the very basics, this just is ridiculous what happened to Jack. And we were able to maintain that focused evidence presentation, and by staying on that straight line, it was great that the jury it made it hard for the defense to really poke holes in it, because we weren't trying to overreach. We didn't need to make the case something more than it was to win, and we didn't. I will say one other thing, though. My favorite part of this trial is when Henner Gracie was on the stand. He brought his mats with him, put them on the courtroom floor, and then started explaining to the jury exactly what Brazilian Jiu-Jitsu is. Used me as his test dummy, and he didn't even tell me what he was going to do. He's like, hey, so the great thing when you get really good at jiu-jitsu, like I am as a black belt instructor, I have total control over my student, for example. And then all of a sudden something happened, and I was laying flat on the ground with my arm straight up in the air. He's like, I got him in an arm bar right now. He can't do anything without me doing it. You know what? Watch, or I'll make him move. And then he just, like, whatever he did, he did. And I don't know how I got there. I don't even know how it happened. And then he just did it. And it was so cool. And the jury was both learning and laughing and loving it at the same time. And isn't that awesome when it's fun to learn? And so the jury was having fun learning about the case, and I was having fun being a part of that teaching process. And then ultimately it got to the next thing, which is then he puts me into this position where my forehead is about 1/4 of an inch from the ground, and I'm facing the jury. And from that, he's able to explain, like, when we talk about putting somebody into this position, which is a well-known position in jiu-jitsu, the turtle position, as an instructor, if I jam his head forward, what's going to happen? It's going to go straight into the mat, and it's going to compress his spine, and that's how you break someone's neck. If you want to break someone's neck, all you got to do is jam them forward, right? Now, how do you defend against that? You've got your two arms, and that may give you a chance to at least prevent your head from getting jammed forward. Tragically here, Mr. Iturralde took Mr. Greener's arm and wrapped it, so he didn't even have one of his arms there, which left the student incredibly unbalanced, and left him fully exposed should an instructor do something stupid and insane as jamming him forward as opposed to rolling him on the side. And then kind of just showed how quickly and easily it could have happened. And that put a lot of context to the jury of understanding how reckless, dangerous, and unnecessary it was what Mr. Iturralde did to Jack at the time he did it. And how, as an instructor in a practice situation, should be very It's not competition. It's a time when you can actually make very conscious and intentional decisions. And unfortunately and tragically, those were the intentional decisions Mr. Iturralde did, which were unsafe and incredibly risky. So I thought that was the best way to teach the jury, and I had the most fun. I'm not normally a prop guy or the guy who it actually is the prop. It's, I call it a discomfort level or something like that. But I really actually enjoyed trying it out, doing it, and it's inspired me that I think I'm going to try these things out in cases to come.
A few more reenactments.
Yeah.
How about rebuttal? What are your thoughts on rebuttal and how do you approach it?
It depends. My co-counsel, Sean Morris, did the rebuttal in this case, and
really?
He did a really good job. But we decided as a team that barring a over-the-top closing argument, being, bordering on unprofessional by the defense lawyer, that we were going to continue to be honest and level in our rebuttal. And, there was nothing unprofessional or crossing the line done by the defense counsel that warranted us changing that strategy. And so Sean, in his rebuttal, was very short, may have been 10 minutes, and really just hit a couple of the points to dispel some of the arguments that were made by the defense, and then closed with a very poignant thing where he said, Jack Greener walked into that Brazilian Jiu-Jitsu club and he never walked out. And that was so poetic on so many levels about what happened to him in there, literally, and that they changed the person that he is and will ever be and put him on a totally different life path and a difficult one by causing that harm. So I thought he did a really amazing job in his rebuttal there, in kind of hitting the points and not losing any credibility with this jury while still touching their hearts.
Well, Rahul, brings us to the end of our time here today. Walk through trial and walk through everything we need to do. So thanks for visiting with us.
Oh, thank you, Dan.
I can't wait to actually do this and prep with you to do this, Jack's case coming up in August. And I look forward to also just the process of getting ready with your firm to, help, put on this program and put on your track and teach so many people how you guys just consistently and continue to get just great results for your clients and build such a great team there at PSR. So
thank you. Thank you for having me, Dan. Anything I can do to help anybody anytime, it brings me joy.
How do we get a hold of you? Shit.
Oh, yeah. You could.
How do people get a hold of you?
Call, email. My email is ravipudi@panish.law. Cell phone 310-409-9271. Call, text, email. If you need anything, if you need any briefing on issues, I'm here for you, and I'd be happy to help.
Thanks, Rahul. And my cell is 248-808-3130. Email dan@triallawyeruniversity.com. If anybody has any questions about our boot camps, our on-demand or live conferences, and if anybody needs financial assistance to come to Vegas, with the tuition and stuff, just give me a call, email me, let me know the situation, and I will do everything I can to, make it so that money's not the reason you're not there. That's all I can say. That's what I'll do.
All right. Thank you.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyeruniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.